Good afternoon, everyone, and welcome. My name is Keith Bybee, and I direct the Institute for the Study of Judiciary, Politics, and Media here at Syracuse University. And every spring, we have a lecture series on law, politics, and the media. For those of you who come to our regular lectures, I should just apologize for last week. We had Chief Judge Robert Katzman scheduled to speak, and unfortunately, he became down with a pretty serious cold the day of his scheduled lecture and had to cancel. But we're hopeful that we'll be able to get Chief Judge Katzman back to the College of Law next year. So stay tuned, be on the lookout for that. The speaker series on law, politics, and the media is sponsored by IJPM and the Tully Center for Free Speech, which is directed by that young man there, the Chief Judge of my court, Roy Gutterman. We often have speakers who look at either media and politics or law and media. Today we have a speaker who's going to be addressing the intersection between law and politics. She is Jenny Diamond Cheng. She teaches at Vanderbilt Law School. Her research focuses on political and legal treatment of families and children, and she is one of the preeminent experts on the 26th Amendment to the Constitution. The title of her lecture is Voting Rights for Millennials. Before I turn over the podium to her, let me just say a few things about protocol. Professor Diamond Cheng will speak for about 35 minutes, and then we'll have Q&A with the audience until 5 o'clock. At that point, we will wheel a couple of tables into the room that'll be groaning under the weight of pizza and sandwiches and cookies, and we'll have a reception right here. So I encourage you, if your schedule allows, to stick around for some food and continued conversation. Without further ado, please join me in welcoming Professor Diamond Cheng.
Hi, everyone. Thanks so much for having me here today. I'm delighted to be here. Thank you so much to Keith and Roy and Shannon and everyone at the Institute for the Study of the Judiciary, Politics, and the Media for inviting me. And thank you also to the Syracuse Law Review for inviting me to write the paper which led to this talk and for their fantastic work making my paper a lot better. So I really appreciate your work on that. So today, as Professor Bybee said, I'm going to be talking about some of the recent political and legal battles over voting rights. As many of you know, we're in a historical moment right now where there's a lot of battle over voting rights. And in particular, I'm going to focus on a subset of that conversation, which has to do with young people voting rights, and both from a political and legal perspective. And in particular, I'm going to concentrate on the role of the 26th Amendment to the Constitution. The 26th Amendment was passed in 1971 and lowered the voting age from 21 to 18. And as I'll talk about later, immediately after passage, it was the subject of a number of cases, but then it really sort of faded from the legal landscape for about 30 years, and more recently has been invoked in a number of major pieces of litigation. And I will argue that the 26th Amendment should be interpreted like the 15th Amendment, to ban intentional discrimination on the basis of age. Okay, but I'd like to start, before we get to the 26th Amendment, by talking about millennials, and particularly millennials as voters, which I imagine is most of you in the room. So, let's see here. Okay, who are young voters? Well, the first thing to know is that there's a lot of them. There's a lot of millennial voters. This is a population pyramid for 2016, and you can see each age group is in 5-year chunks. The blue is male, and the pink is female. And the baby boomers, you can see here, the baby boomers are those born between 1946 and 1964. They're now between ages 54 and 71, and they were the largest subgroup in the United States until 2015, when they were overtaken by 18 to 34-year-olds, also known as millennials, also known as echo boomers. And in fact, for the first time in the election of 2016, the number of eligible voters in the millennial cohort outnumbered those in the baby boom. So the biggest age cohort in the 2016 election were 18 to 34-year-olds. So the next thing to know is that this 18 to 29, 18 to 34-year-old group is significantly more racially diverse than our older groups. You probably already know this, although not quite as diverse as those under 18, but dramatically more non-white than the older age groups. In fact, for school-age children, about half of all public school children in the United States at this point are non-white, but much more racially diverse. And as I will argue, to my mind, this gives an additional reason for treating racial voter discrimination and voter discrimination on the basis of age similarly, because they're increasingly related. So, turning to voting. Young people, for all their numbers, vote a lot less than do older age groups. This shows voting rates over time for the voting age population from 1964 through 2012. You can see here, this is the point at which the voting age was lower for the 1972. This was the first point at which 18-year-olds could vote, and the voting age went even lower. So turnout rates vary enormously by age. Young people vote a lot less than older people do. However, there's a couple of caveats. First of all, some of this is due to the fact that there's a higher percentage of non-citizens in younger age groups. So there's a higher percentage of people who are not eligible to vote. So if you compare the voting eligible population, it's a little less dramatic, although the basic chart still holds. Furthermore, when you compare registered voters across age groups, there's also somewhat more convergence. It's less dramatic a difference when you compare the turnout among registered voters across age groups. The real difference is in voter registration. Young people are far, far less likely to be registered to vote in the first place than our older voters. All right, so how do these young people vote? So this is data from the 2016 exit poll. And so this is not perfect data by any stretch of the imagination. In particular, I think that this 10% for third party, this is a hard number to gauge, and there's a couple of numbers floating around the literature. We'll probably get better numbers over the next year or so. But you can see that the younger the voter, the more likely they are to vote Democratic. The older the voter, the more likely they are to vote Republican. Okay, so strong at this particular point in history, there's a strong Democratic leaning among the millennial voters. And you can see over time, actually, let me back up one second. I hope that you read the Circle report that some of you were assigned to read. And I just wanted to note that while obviously this breaks it down by age group, it's somewhat more complicated when you look at gender and race within the age groups. So again, young millennial white male voters did break for Trump. Less strongly than their older counterparts did, but they did. Certainly the majority of them voted for Trump. There are fewer of those voters in that younger age cohort. So there's a couple of things going on at once. And this data does conceal a lot of complexities. Okay, how does this result compare over time? So as you can see, this is from 1972, the first election in which 18-year-olds were eligible to vote, through 2016. You can see that young people have tended to vote Democratic, although not in every single election. They broke for Reagan here, and not always as strongly. And as I will talk about when I talk about the history of the 26th Amendment, this was true in earlier decades as well. Young people tended to vote Democratic. They voted for the Democratic candidate more often than not. But just as they broke for Reagan, they also broke for Eisenhower. It wasn't necessarily true in every single election. This, I think, is a really neat graphic that shows us the generation gap over time. So one of the arguments has been that, the observations has been, is that the distance between young voters' political preferences and the political preferences of older voters is widening. You can see this goes up to 2012, where there was the same difference as there was in the 1972 McGovern-Nixon election, and then in 2016, it was even wider. It was a 19-point gap between 18 to 29-year-olds and 65-plus-year-olds in terms of the political preferences. What's more is that there's research showing that within their political identification, young people are further to the left. So young people are not only more likely to vote Democratic, they are more likely to Democratic voters are more likely to identify as liberal Democrats. And older voters are more likely to identify as conservative Republicans. So I think there's reason to think that this graph actually understates what the real generation gap in political preferences. Okay, so how does this relate to recent conversations about voting rights and voting restrictions? So since the midterm elections of 2010, a whole bunch of states, primarily those with Republican-dominated legislatures, have introduced legislation to restrict voting. Most commonly, photo ID requirements, also laws restricting early voting, absentee voting, new requirements for voter registration. I have here a graph. So the light red were states that had new restrictions in place for the 2012 election. Dark red is states that had restrictions in place for the first time in 2016. Now, much of the conversation about and the litigation about these new laws revolves around how they do or do not arguably discriminate against minority voters. And I'll talk about the legal framework for those challenges in a minute. However, it's somewhat less a part of the conversation that some of these laws are either targeted at or have arguably a disproportionate impact on young voters. For example, I'm from Tennessee. I'm not originally from Tennessee, but I live in Tennessee. And in Tennessee, you have to show a photo ID to vote. You can use your driver's license. You can use your gun permit card. You can use, if you are an employee of a state university, you can use your employee card. But if you are a student at a state university, you cannot use that as a voter ID card. It has to be only if you're an employee or staff member, not if you are a student. You have other places where early voting sites have been moved away from universities. Rule changes in law pertaining to residency and how that relates to living in a dorm, for example. Now, I should note here that this is not a new concept. So as I mentioned before, immediately after the 26th Amendment was ratified, there was a wave of litigation, mostly having to do with municipal ordinances in college towns. So a number of college towns quickly enacted ordinances or retimed their elections to try to prevent resident students from voting. A number of them were challenged on 26th Amendment grounds. Some were upheld, some were struck down. But we did not get a clear interpretation of the 26th Amendment out of this litigation. And what's more, the litigation today is different. The 26th Amendment challenges are coming up in broader context as part of bigger cases that are challenging these state laws on a number of grounds, not just about the effect on the young. Okay, so most of this litigation challenging state voter ID laws as being racially discriminatory has relied on a number of different legal pieces. So first you have the 15th Amendment, which I mentioned before, and the 15th Amendment has been interpreted as prohibiting voter discrimination on the basis of race if it is intentionally discriminatory. So it prohibits intentional voter discrimination on the basis of race. Next, you have the Equal Protection Clause of the 14th Amendment, which prohibits, requires strict scrutiny for any kind of racial discriminatory law and sort of effectively invalidates a law that can be proven to be intentionally discriminatory on the basis of race. And finally, we have the Voting Rights Act, specifically Section 2 of the Voting Rights Act, which prohibits laws that have either the purpose or the result of discriminating on the basis of race. Now, obviously, there's a lot of litigation, a lot of questions. What is result? How do you actually prove result? Can you prove result in the absence of intent? But it is certainly a broader framework than you have under the Equal Protection Clause or the 15th Amendment, and as such, that has tended to be the focus of plaintiffs seeking to challenge state voter ID laws. However, most of this isn't particularly relevant to challenging voter ID laws on the basis that they are discriminatory against young voters. For the Equal Protection Clause, as you should know, age is not a suspect class. So a law that is discriminatory on the basis of age need only meet rational basis review. This is not a part of the Voting Rights Act, at least not with respect to the Supreme Court struck down, as I'll talk about later, a piece of the Voting Rights Act that did have to do with lowering the voting age, but only as it pertained to state elections. There is some relevant case law having to do with the First and 14th Amendment being interpreted together to require a balancing test. And in fact, that was a significant aspect of doctrine in one of the cases I talk about in my paper in Wisconsin, but it doesn't specifically have to do with age discrimination. So to make that claim, the most relevant text is the 26th Amendment, which is, here you go. Okay, here's a text of the 26th Amendment. As I mentioned before, there's very little doctrine on it, so the courts are currently grappling with how to interpret this. And there's been three, sort of both between the case law and the commentators, there have been three big approaches. So most broadly, a couple of commentators have argued that the 26th Amendment prohibits age discrimination broadly, young, old, but just any kind of discrimination on the basis of age. This is not really caught on in the courts, but it's out there in the literature. Next, we have claims, oftentimes from the states defending voter ID laws, that all this does is move the age at which it is acceptable to discriminate on the basis of age. That it merely prohibits setting your voting age higher than 18, and you're still discriminating on the basis of age, you're just changing the point at which it is acceptable to do so. Finally, there is the interpretation floating around that I am pushing here today, which is that as an analog to the 15th Amendment, the 26th Amendment prohibits intentional discrimination, intentional voter discrimination on the basis of age. And as I discussed in my paper, I think there's a slowly and haltingly a legal consensus developing around this last interpretation. At least the federal courts considering the cases have seemed open to them. They have not actually struck down any law on this basis, but in their discussion, this particular interpretation seems to be gaining increasing traction, most notably in a case out of the Western District of Wisconsin. I think that's the case from last year, where we see a court most explicitly adopting this idea that the 26th Amendment is the 15th Amendment, just with age instead of race as the relevant category. That case is currently on review with the Seventh Circuit, which seemed very skeptical of the plaintiff's claims generally, so we will see what happens with that case. Okay, so my argument is that this is the correct interpretation, that this is the way to think about the 26th Amendment, although for different reasons than have been generally advocated so far. In particular, I want to argue that it is the text of the amendment rather than the amendment's history, as well as these demographic changes that I pointed to before that suggest that this is the correct interpretation of the amendment. So in figuring out how to interpret the amendment, history is not of much help. So people on all sides advocating a wide range of variety of interpretations have looked to the amendment's history for backing, for originalist explanations about what the framers intended, and come up with competing explanations. I have studied this amendment for a number of years, and what I have found is generally they're often both right, and that in the actual historical record simply isn't of much help in choosing between them. And I will take you quickly through that history right now, and I'm going to highlight 3 points in my little recitation here. The first is that the reasons for lowering the voting age shifted over time. Lawmakers advocated different arguments at different time in response to different historical phenomenon. They waxed and waned in their sort of persuasive power. There are arguments that were really compelling at a particular time that seem silly to us now. And oftentimes, the sort of balance of logic didn't necessarily have much to do with the persuasive power at any given moment. Second, partisan politics were always relevant. Both parties sought to lower the voting age when they thought it would help them at the ballot box, and they were against it when they thought it would hurt them. Finally, almost nobody ever cared about the actual text of the amendment. The specific wording was essentially of no interest to anybody ever. And I'll talk more about that. Okay, quick summary. So 1940s, the first proposals to lower the voting age from 21 to 18 surfaced in World War II, right after Congress voted to lower the draft age from 21 to 18. And when I mean right after, I mean that same day. So they voted to lower the draft age. A couple hours later, you have proposals to lower the voting age as well. And the key argument here was that it was unfair to draft soldiers who couldn't vote. So this is a sort of quintessential quote here from one of the early proponents of 18-year-old voting, Senator Vandenberg from Michigan. And you see this logic here. Now, since the Congress had just moments before voted to draft people who couldn't vote, this argument was of limited power. Right? They had just said, it's fine to draft people who won't vote. We're going to draft 18-year-olds. So the power of saying, well, you have to give draftees a vote was of limited persuasive power. And what's more, a number of the reasons that were advocated, that were advanced for lowering the draft age were at odds with other arguments to lower the voting age. For example, one of the arguments for lowering the draft age was young people are more obedient. They are more likely to follow orders. They are more reckless and willing to run into battle. They have jobs that are not as crucial to the economy. They don't have dependents and are essentially more dispensable. So those kind of arguments did not play as well when it came to start talking about voting. And so this argument, that this movement didn't really get off the ground, although Georgia, at this point, did lower its voting age. This was, as you can see, Vandenberg was a Republican. This wasn't a super partisan conversation, although it tended to lean Democratic. And Georgia at the time had a young, very liberal Democratic governor who took on this cause. And Georgia did, in fact, lower their voting age in 1943. They were the only state to do so until Kentucky lowered it in 1955. I should note here that the text of this text, the core text here, was essentially is the same text as was proposed in 1942. So for the first couple of years, over the years, you had hundreds of these proposed amendments introduced, and for the first couple of years, there were slightly different formulations. One of which was this, but after about 1943. That was it. They all looked exactly the same. And so there's one hearing at which a member of Congress said, hey, where did this text come from? And everyone kind of hemmed and hawed. And then someone said, oh, I think it was drafted by our Office of Legislation, so some staffer. Oh, okay. And that was it. There was never any more conversation about which version to pick, what the wording should consist of, ever. That was just it. This was the text, and this was what was going to be right through to the very end. Okay, 1950s. So we have this push in the early 40s, dies out by the end of the decade. Early 1950s, young people start to poll Republican. And this becomes a Republican initiative, particularly at the national level. The National Party takes a real interest. President Eisenhower advocates lowering the voting age. You get a number of state and local officials who are dubious. Like they're not really, Republican local officials, they're not really convinced that these young people are going to vote Republican, but the National Party is really interested in it. And in fact, a proposal gets as far as a failed vote on the Senate floor. The Republicans vote in favor. It was actually scheduled late for a Friday afternoon, so there was not a lot of turnout. But of those who were there, Republicans voted in favor, Democrats voted against, and the Southern Democrats stood up and spoke very strongly against it. So during this time, you still have conversations about the draft. People saying, if you're old enough to fight, you're old enough to vote, particularly during the Korean War. But you also have the conversation, the tenor of the conversation shifts. And you start to have more arguments about education, about young people being more informed than they used to be. Young people should vote because they're more sophisticated. There's television now. They can see, they know more about the world of politics. And you have this great quote here from Senator Dirksen. I'll just let you read this. This is a little over the top, but it will give you a sense, a flavor of what this kind of conversation sounded like. And it sounds goofy now, right? But at the time, it really was more of all of a piece of post-war optimism, the sense that all of these children, these baby boomers are the future, the world is getting better. And so a lot of the conversation, to a degree that I think surprises us today, was wrapped up in this idea, we should lower the voting age, not just because it's just, but it'll make America better. These young people are the future. They're better educated. What are we spending all this money on education for if they're not going to be better citizens? All right, so early 1950s, once again, you have this spike of interest, falls off the agenda by the end of this decade again. Early 1960s, there starts to be more interest again in lowering the voting age, comes up in the context of the voting rights for the District of Columbia. There's some advocacy of lowering the voting age as a way to remedy low turnout. But things really start to get interesting in the late 1960s. So the escalation of the Vietnam War brings new intensity to this long-standing argument that soldiers should have the right to vote for people who are sending them to war, particularly since young people are at the forefront of opposition to the war. This argument takes on new heft. And then there are the student demonstrations themselves, which actually cut in opposite ways. So on the one hand, at the state level, you see a number of state referenda to lower the voting age fail. And in large part because people are very, very upset about these demonstrators. They were not enfranchising these young people. They're out of control. How dare they ask for this? There was one proposal that they could only vote if they cut their hair. So this is really wrapped into the tenor of the times. But at the federal level, these legislatures who are really under a lot of pressure to do something about these demonstrations, to do something, anything, start saying, well, if we lowered the voting age, maybe these crazy kids would get off the street and vote instead to channel their dissent. Oh, I keep doing that. So here's another quote that exemplifies this perspective here. So this idea that the vote can be a safety valve, a way to channel this very frightening anger that is driving young people onto the streets. Maybe if they can vote, they'll confine their activities to traditional electoral politics, which is much less scary. And again, this is one of these arguments that seems strange to modern ears. Sometimes people say, oh, surely no one took this seriously, right? But I think it was quite genuine. Again, these senators and congresspeople were under a lot of pressure to do something, anything to stop this. I should also note that the McGovern campaign that you saw noted in one of the charts earlier in 1968 had a big effect in that you saw a lot of youth participation, a lot of volunteers. And so one of the things that comes up in the legislative debates are these Congress people saying, wow, like I was really impressed by all these young volunteers. If we lower the voting age, maybe they'll keep doing this. So there was definitely a sense that there were not only votes to be had, but free and enthusiastic volunteers who might be more motivated to come to their office and help out in their campaign if they could vote. Okay, so 1970, the Voting Rights Act comes up for renewal. So as I said, you have a series of proposals coming up, more and more proposals to lower the voting age by constitutional amendment. 1970, it's time to renew the Voting Rights Act of 1965. And Senators Ted Kennedy from Massachusetts and Mike Mansfield from Montana hatch a plan. So one of the key reasons why these amendments never got off the ground was the implacable opposition of the congressman from New York, Emanuel Seller, who was also the chair of the House Judiciary Committee. And his committee was just a killing ground for these proposals for decades. He was strongly, strongly opposed to it. And Mansfield and Kennedy came up with this strategy of attaching a rider to this piece of legislation that they knew was Seller's baby. He was very committed to the Voting Rights Act, very committed to its renewal, and they attached it and essentially painted him into a box. There was a point at which, if the amendment was voted, the rider was voted down, the renewal bill would have to go back to conference committee. And the conference committee at the time was headed by a segregationist. And he didn't want that to happen. So there's a point at which Seller gets up on the floor and says, I've never been in favor of this. Maybe it won't be so bad. But the really important thing here is that the Voting Rights Act be renewed. That's what's really important. And so the Voting Rights Act, with this rider, which lowers the voting age in both state and federal elections, passes. Immediately appealed to the Supreme Court. And in a highly fractured opinion, the Supreme Court strikes down the statutory provision with respect to state elections, but not federal elections. So the holding here is that Congress doesn't have power under Section 5 of the 14th Amendment to lower the voting age in state elections, but it does in federal elections. In response, all of these states which had not yet lowered their voting age, as at this point you have Georgia lowered it in 43, Kentucky in 55, Hawaii and Alaska entered the Union with slightly lower age. I don't think either of them had 18 at that point. So all these other states were faced with the possibility of having to administer a dual age system for the 1972 election, right? There would be they'd have to let 18, 19, and 20-year-olds vote in the election for president, but not in their own state elections. So you immediately have this flurry of activity at the state level, and you have this flurry of activity in the federal level. Both houses of Congress quickly approve a constitutional amendment to lower the voting age, and it is ratified in record speed, breaking the record that was previously held by the 12th Amendment, and it is signed and made a part of the United States Constitution. So, if you're looking for original intent or a coherent legislative motive here, this historical resuscitation isn't actually of that much help. So, there were some legislators who really did think of this bill as broad anti-discrimination legislation for young people. This is about equality. This is about making young people full participants in our political process. Other people thought they were just linking up the voting age and the draft age. It was really about soldiers. Still others were concerned solely about partisan politics. Right? That was the main motive. And still others were primarily concerned about getting these demonstrators off the street. So you really had a lot of intents, and it's hard to come up with a clear interpretation based on that story. So again, I think that the most appropriate way to handle this then is to look at the text. And the 26th Amendment looks just like the 15th Amendment. It also looks like the 19th Amendment, which has to do with voting rights for women, and the 24th Amendment, which abolished the poll tax. This all has the same wording here. This is what's known as intratextualism. The idea is that you read constitutional provisions that have the same language, should be interpreted the same way, regardless of what the intent was, regardless of whether the framers intended them to be read this way or not, but that the text itself should be read in parallel. So the Supreme Court has held that the 15th Amendment, as I said before, prohibits intentional discrimination on the basis of race. And in a case called Village of Arlington Heights, the court set out a framework for evaluating this and established 6 factors that go into evaluate that the court should look at to determine whether there was intentional discrimination or not. And to my mind, this is the most intellectually honest way to interpret the 26th Amendment. I think a key benefit is that it doesn't create incentives to misread the historical record, which is really very interesting and very complicated, but it just isn't all that helpful in terms of interpretation. Okay, so what are the key arguments against interpreting it this way? So I think the best counter-argument, for those of you who read the Judith Sklar excerpt that I sent along, I think the key counter-argument is, look, age and race are just different, right? Racial discrimination in voting is just more problematic, more stigmatizing, and more corrosive than discrimination on the basis of age. And hey, by the way, age discrimination is still baked in here, right? We're not getting rid of discrimination on the basis of age, we're just changing the point at which it happens. And while I think that's a pretty good argument, I think that there's one response is that, yes, it is, I think she's right, it is less stigmatizing. It is less stigmatizing to being young, as she says, is not a permanent condition. There's nothing it doesn't carry on all this negative connotations, all this negative history. Maybe it's not stigmatizing, but I think it's pernicious. Discrimination on the basis of age is pernicious in a different way, which is that it is problematic to make it especially hard for people to begin voting, right? If voting is a habit, limiting the right to vote for people who are just becoming eligible can have, to my mind, negative consequences long-term on your democracy. What's more, and I think this is probably the stronger argument, these two categories are kind of converging, right? As we saw before, are states that are trying to make it more difficult for young people to vote doing so because young people are more likely to vote Democratic because they are young, or because they are more likely to vote Democratic because they are more heavily non-white? These two categories are converging, and I think, therefore, the idea of racial discrimination in voting and the idea of age discrimination in voting are starting to operate together in a way that suggests that it makes sense to interpret these two constitutional provisions together. Okay, I'm going to wrap up here with a couple of open issues. So One big problem with my interpretation is that courts are historically really reluctant to find intent. Right? When you say discriminatory intent, that's a really high standard. And in fact, as I mentioned before, none of the cases that have considered these 26th Amendment claims, although some of them have, in fact, gone with my interpretation, none of them have actually struck down anything on the basis of being intentionally discriminatory on the basis of age here. And in fact, there have been evidentiary issues come up where in evidence of lawmakers either speaking to reporters or making statements to certain supporters that would arguably be compelling evidence of discriminatory intent have been excluded on hearsay grounds or on legislative privilege grounds. So I think this is a valid critique, right? If you say, well, this is going to prohibit intentional discrimination on the basis of age, but then make it impossible to actually prove discrimination on the basis of age, that's not a very helpful interpretation. To my mind, I think that this is better addressed through the rules of evidence and through challenging. I think there's a lot of room for challenge, particularly this idea of legislative privilege, that the reasons why the evidence is being excluded. I think that is a better approach than messing with constitutional interpretation. But finally, there's a bigger question. And it has to do with the role of partisan politics, which I think brings us back to the theme of this course here, right? The relationship between law and politics. If everyone's motivated by partisanship, is there anything different between expanding the right to vote and narrowing the right to vote? Right? Is it more problematic or less problematic for Democrats to try to make it easier to vote because they think it will help them win, or for Republicans to make it harder for young people to vote because they think it'll make it easier for them to win? And this is something that came up in the Seventh Circuit's oral argument over the One Wisconsin Institute case, I think just last week or the week before. Judge Easterbrook said, well, that can't be right. It can't be right that it's okay to have, for partisan reasons, expand voting rights, but not okay to limit them. And so I think I think it's a tough question. I'd be interested to know some of your thoughts on it. So with that, thank you very much. I'm looking forward to hearing your questions. I'm going to turn this off so it's not like backlighting me here. Okay, great. So, questions? Thoughts? Yes, please.
We can still shut system.
Okay, have a
Yeah. But I can ask a question while you're doing that.
Okay.
Is the system off thing you can?
Over here?
Maybe.
Yes, system off. Okay, we have the same one. This is what we have it. Oh, look at that. Okay. All right.
Well, anyway.
Oh, should I?
Well, that's fine.
Okay.
So I wanted to ask you about age and race discrimination.
Sure.
Push on that a little bit. I mean, even if there is some instances where age might be a proxy for race, one of the old arguments to differentiate suspect classes from non-suspect classes is about the kind of sympathies that a governing majority might have for members of a class. So given that, say, for example, African Americans are a numerical minority in the American polity, and that disproportionately do not occupy positions of power, so they're outside of the halls of power, you might think that governing majorities in legislatures and governments around the country are going to lack interest, awareness, sympathy for the concerns and rights of African Americans. When it comes to age, you say, well, everybody in the legislature was young once, right? And even some young people in the legislature and older people, and so we're not in the same situation where we don't think there's some kind of mechanism for conveying the interests and concerns into the halls of power. And so this is.
I think that's a great point, and I think it's one of the. I think I would not necessarily, I'm not necessarily sold on the idea that age is a suspect class in terms of equal protection analysis. I think for here we're not talking about general, we're talking about specifically with voting. And for me, voting is sort of a more problematic category, and the discrimination is more problematic, and distinctions in that category, which I think is reflective of sort of general constitutional jurisprudence, right? This idea of substantive equal protection, that when you're talking about making distinctions for voting, you need to give a better reason for it. And I think there's this particular problem with young people voting, sort of voter discrimination against young people, because voting is such a habit. Right? It's a habit-forming thing. So to my mind, I think it's a great point, and I think it's a really sort of undermines argument, the sort of broadest interpretation that this is really about age discrimination more broadly. But to my mind, voting is somewhat different. That's a great question. Thank you. Yes.
I have a quick question.
Sure.
So I know that you said that when people get, or the older age group is predominantly Republican and the younger age group is predominantly liberal. Is that because, and then the next group that can't vote, they're even more diverse. Do you think that it's because as you get older, you have different life experiences that make you more conservative, or is it because during your upbringing, like with our age group, we're a little more diverse, and the next age group is even more diverse, which makes them liberal?
So it's a great question. I think we're going to see a lot more on this. I think particularly the relationship between age and race and pulling out the political preferences and what connects to what is something we're going to see a lot more of. I think it's hard to know that sort of why are young people, and this is something that has been asked periodically through history, why are young people so strongly Democratic? Again, they haven't always been. Sometimes they are, and sometimes they're not. I think it may have to do with the particular issues that are at the forefront of political discourse at any particular time. That has to do with the political preferences. But I think, the fact that this generation gap is so broad at this moment is that we're seeing more work on it. There's more people studying it and trying to pull apart why exactly are we having such a historically large generation gap at this particular moment. But I think it's both a function of the people themselves and then the issues that happen to be dominating our landscape. Does that answer your question?
Yeah.
Okay, great. Yes, in the back.
You were mentioning how this is the younger generation is more knowledgeable on more things as time goes on and technology evolves and all that. Do you think that voter participation is going to be so, there can be such a large difference or disparity between younger voter turnout and whatever the millennials are going to be in 20 years? Do you think that 18 to 34-year-olds are going to vote still less than they do now?
So interesting question. So I would point to that was a function of the 1950s. That conversation is not something you really hear very much now. So, but in the 1950s, that was really a part, that was very much a part of the discourse. And then it turned out when that age group did get the vote, they didn't actually vote all that much. Will this continue? I don't know. And I think some of this, again, voting is a habit. On the other hand, yes, people do. As people get older, again, so voting is a habit. On the other hand, when you have people, sorry, I've lost the train of my thought here. So part of it is that it becomes easier to register as you get older, right? And that I think to the extent that the difference is due in part to registration rather than voting, if it becomes easier to register as you get older, then perhaps that will disappear. On the other hand, if you make it harder and harder to vote when you're young, then yes, it might. I think we're just going to have to see. That answer your question? Yes.
I had a question about registration.
Sure.
And talking especially with college students,
Mm-hmm.
I have two questions. One, what can be done on a kind of political level, and what can be done on a legal level for changing and increasing the ease with which people can register? So, for example, when I was an undergraduate here, I was in charge of the Obama campaign in 2012, and very easy in New York. You just hand out, you sit at a table, you have people fill out a form, and then you go to the office, and we think we registered like 600 people that voting. How is that different state by state? How can we combat that? And what are the legal kind of, I know that's a very broad question.
Okay, so I'm going to decline that. I'm not a political organizer, so I can't tell you. You would actually have a better sense in terms of how to actually sort of as a political matter. As a legal matter, I think, as I mentioned before, there's not a lot of legal bases on which to challenge these rules. The legal balance, so how do you challenge sort of decisions about where early voting locations are placed, or rules about whether dorm lists are acceptable to, for proof of residence residents to go to a local board of elections. Like, how do you do that? And so I think the two pieces really are the 26th Amendment, which I'm talking about here today, and then this theory of the combined First and 14th Amendment and a balancing test between the a balancing test for the burdens and benefits of a particular piece of legislation. I think it's it's different than legislation and voting challenges based on racial discrimination. The legal bases are much narrower. Is that adequate?
Yeah, so basically out of the Western District of Wisconsin, you said was the...
Yeah, so that's the one. So there are a number of cases that there's North Carolina, which some of you may have seen, the Fourth Circuit struck down the state voter ID law as being racially discriminatory in a very sort of ringing statement. I believe the phrase was surgically targeted at African-American voters, a really powerful case. But the court had rejected the 26th Amendment challenge didn't make it up to the Fourth Circuit. It had been rejected at the district court level, although the district court had tentatively accepted the interpretation that I am advancing here, had said, no, there wasn't actually any intention here. In Wisconsin, this is the Wisconsin District Court, this is the case that's up on appeal to the Seventh Circuit. There, the district court did, in fact, apply this test. This is the 26th Amendment is the same as the 15th Amendment, but with age as the relevant class. But then said, no, there's not any intentional discrimination. This falls on this combination of First and 14th Amendment. Again, from oral argument, it looks like the Seventh Circuit is likely to reverse that opinion, but I don't know if they're going to say anything at all about the 26th Amendment. Yes. Mm-hmm.
The rationale behind that has been proposed as prevent voter fraud or other.
Sure. Mm-hmm. Mm-hmm.
You also mentioned that you're seeing some judicial skepticism about that argument. I was wondering if you could expand a little bit about what you're seeing.
Sure. So you have a bunch of, and you have a lot of these big sort of impact litigation type cases challenging voter IDs in a number of states. There's just a decision in the Texas case a couple of days ago. Texas District Court struck down that state's. And one of the things that I think you're seeing, and not all of these involve challenges based on the 26th Amendment. Most of them are challenges based on the 15th Amendment, Equal Protection Clause, and especially the Voting Rights, Section 2 of the Voting Rights Act. But yes, I think one thing, you really see this in the Fourth Circuit case that I was just talking about, in the NAACP versus McCrory case, where there have been at this point a number of studies about voter fraud, and they're not finding it. And plaintiffs introduced this, and I think the Supreme Court's previous big decision. This was in a case called Crawford in 2008, where the court said that this is a legitimate requiring photo ID is a legitimate thing for a state to do in order to prevent voter fraud. And what you're seeing in the cases is courts saying, well, this is Crawford, so we have to follow the law, but. They just seem more skeptical of these claims that any given piece of legislation is necessary to combat this problem of voter fraud, given that there's now a fair amount of empirical evidence that there's not that much of a problem of voter fraud, and the incidences are very rare. Yes?
Kind of in the same vein, is that why some states are changing the policy on student IDs for university students? Is there any voter fraud on the basis of maybe students from out of state?
Yes. So that's the argument is fraud. So in Tennessee, so that case went nowhere. A group of Tennessee students challenged. This was actually one of the cases that was not part of a bigger challenge. This was just challenging on 26th Amendment grounds the Tennessee requirement, Tennessee voter ID law in particular, which kinds of ID were legitimate. And the argument, which passed judicial muster, which is that unlike employees, students are more likely to fake their ID. And they're to have fake IDs. Like that's a thing that young people do, is have fake IDs. And so therefore voter fraud is a legitimate reason for disallowing them. So I think that claim has had more power in this particular concept, the claim of fraud, than it has in others. Like the student ID is a more powerful argument. Yes?
You mentioned how hard it is to show discriminatory intent, and then maybe on the flip of that is how easy it is to cover up discriminatory intent. What would you say to someone saying the standard should just be the disproportionate impact, or extreme disproportionate impact should be the standard?
So, to my mind, I think I mean, you have to have a theory for it, right? Like, what would the theory of interpretation be that would get you to that point? To my mind, I think, to have any kind of consistency, I think consistency across the Constitution is a virtue, an independent virtue. To my mind, I think the real problem with this lies in the realm of evidence. And I mentioned this before, that there is evidence of particularly now when you have this fragmentation of the media where people talk to a lot of different audiences and they don't necessarily know what's going to wind up on somebody's blog. And then this stuff is introduced and it's ruled out as hearsay or legislative privilege on, to my mind, not fantastic evidentiary grounds. So I really think that's where the action needs to be, like focusing on not having this sort of more compelling arguments back about, because you don't really see them, right? Like you see in the transcripts of some of these trials, evidence being excluded, the judge is not really quite sure what to do. All right, fine, I'll exclude it. But I think there's space there to really push back, and particularly this idea of legislative privilege for some of this stuff seems to me to be very far-fetched and a rather fragile doctrine. Other questions? Yes. Sure.
We talked a little bit about this at lunch, and I'd like to hear maybe more on it. This is one way of dividing between, I don't know, citizenship and I guess full adult citizenship and not adult citizenship as a voting age. But there are lots of other age requirements in our polity, the age at which you can drink, the age at which you can enlist in the armed services, how long you can stay on your parents' health care insurance. And these are all different ages. Do you think that there's some case to be made thinking about age discrimination, the prohibition of it that's embedded in the 26th Amendment, in your view, to kind of consistently across society to think about some kind of age of maturity or majority or emancipation?
I think it's a great question. I mean, so I had mentioned this at lunch, right? There's two big ways of really thinking about becoming an adult, right? And this ages, right? We have a lot of different ages, right? As Professor Bybee was saying, we have a lot of different legal ages at which you go from being a child to being an adult. And there's two ways to think about this. One is that this is all sort of the product of political happenstance, and this is a sort of inconsistent and problematic, and we really needs to be one moment, right? There needs to be one moment where you cross that boundary from being a child to being an adult, from being a dependent to being an independent and a full-fledged member of the polity, right? So that's one way of thinking. The other way of thinking is that, well, actually all these contexts are completely different. Voting isn't like drinking, which isn't like being dependent on your parents' health care insurance, which isn't like being tried as an adult, which isn't like getting a tattoo, right? And that these are all different contexts, and there's no reason to think they all have to happen at the same time. You become an adult gradually, and it's appropriate for our legal system to reflect that in a series of graduated laws. Do I think the 26th Amendment reflects a particular? Not really. I think some people thought it was. I was obviously trying to pull together the voting age and the draft age. Although, again, I just told you, it got pulled apart. So there's always this countervailing force. And then after the 26th Amendment was passed, a number of states, actually almost all states, immediately lowered their ages of majority, which include the drinking age, which included the age for which for parents had to support their children. And then some of that kind of got pushed back again. The drinking age got moved back up again. There have been challenges to non-custodial parents, what age non-custodial parents have to support their children. So to my mind, it kind of ebbs and flows. There are these times where there's an effort to pull things together, and then it kind of pulls apart. It's administratively also very difficult. So one of the things that you saw after the 26th Amendment was passed in New York, in fact, there were so many places where age appeared in the code that they just gave up. They're like, yeah, we'll just keep it 21. It's administratively very difficult because the way the codes are written, they're complicated and pieced together other times. I don't think the 26th Amendment, it did for some people, and for other people it didn't. Other questions?
We have time for one more question.
Comment?
A moment of reflective silence. We can do that too. If there are no questions,
Okay.
please join me in
Thank you. Thanks so much.